Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is right here. Welcome back, everyone, for some more SPTV, where every day is a great day not to be in a cult. We have an update this morning in one of the 5 lawsuits against Scientology and its leader, David Miscavige. This one is a little disappointing. There's a hearing this morning, 9 a.m. Pacific time, in the lawsuit brought by 3 of Danny Masterson's victims. We're talking about Jane Doe 1, 2, and 3. This lawsuit also includes Jane Doe 3's husband, Cedric Bixler Zavala, and another one of Danny Masterson's victims named Babette Reales. This lawsuit was filed 5 years ago and was put on hold during Danny Masterson's trials. Once Danny Masterson was convicted and sent to prison, this lawsuit was taken off of its stay and got going again. The update, unfortunately, this morning is that it looks like this lawsuit is going to be put on ice for approximately a year while Scientology appeals a ruling in the case. This lawsuit currently has 5 causes of action and 5 plaintiffs. The first cause of action is stalking. The second is physical invasion of privacy. The third is constructive invasion of privacy. The fourth is intentional infliction of emotional distress. The fifth is loss of consortium. Now, Scientology filed an anti-SLAPP motion against this lawsuit, specifically against the first, fourth, and fifth causes of action. Scientology's position was that as a notorious international multi-billion-dollar family-destroying human trafficking cult, it is in fact their constitutionally protected activity to stalk, to intentionally inflict emotional distress, and to cause loss of consortium. Because of course it is. The judge summarily dismissed the entire anti-SLAPP motion, and Scientology is predictably appealing that ruling. In the meantime, the judge ordered a few months ago that this entire lawsuit be put on a stay. Now, the plaintiffs understandably felt that putting the entire lawsuit on a stay wasn't necessary because no matter what happens with the anti-SLAPP stuff, there are still 2 entire causes of action that Scientology never challenged and is not appealing. And no matter what happens with the anti-SLAPP stuff, these 2 causes of action remain, and discovery and depositions should be able to move forward on the physical invasion of privacy and constructive invasion of privacy causes of action. This would allow them to move forward with trying to depose David Miscavige, Danny Masterson, and many other high-profile Scientologists and representatives of Scientology itself. So the plaintiff's team has filed a motion asking the judge to reconsider his decision to put the entire case on hold, and that is the hearing that is occurring this morning, 9 a.m. Pacific. Late last night, the judge published his tentative ruling on this matter, and unfortunately, it looks like he's going to rule against the plaintiffs, and that the reason for doing so is that the precise procedure for making this request for reconsideration wasn't exactly followed, and also that the correct window to make this request has already closed, which is a bummer. So let me show you parts of this tentative ruling. We have it right here. Judge Kalra, in the case Chrissy Cornell Bixler et al. Versus Church of Scientology International et al., requested relief and order reconsidering the scope of the stay articulated in the court's May 29 ruling on plaintiff's motion for leave to file a second amended complaint. Tentative ruling, motion for reconsideration is denied. There is another element to the proceedings of this particular lawsuit that I didn't specify, that as a layman, my interpretation of all this leads me to believe this was a contributing factor to possibly this particular request being denied. And that has to do with the fact that, well, 3 things are happening at the same time. You have Scientology trying to appeal a decision regarding 3 of the 5 causes of action. The plaintiffs have, in the case history, both requested permission to file a second amended complaint to add additional complaints and to add an additional plaintiff. That matter has not been put to rest yet. At the same time, you have the plaintiff's team asking the judge for permission to move forward with discovery and depositions regarding at least two of the five causes of action in the first amended complaint. So again, as a layman, I can see where the matter might be confusing enough, aside from the procedural issues that the judge has taken issue with. The matter might be confusing enough that the best thing to do right now is we're going to take a timeout. First of all, the timeout is so the appeal process can carry on and be completed, which the chances of Scientology winning on this appeal seems to be very, very low. But also, the plaintiff's team seems to need to actually make a final decision on, are they asking to move forward with the first amended complaint, or are they still asking for permission to leave to make a second amended complaint? The additional claims that the plaintiff's team was looking to add to this lawsuit was the sexual abuse claims against Danny Masterson, Masterson. Remember, this lawsuit was not about Danny Masterson's sexual assaults. This lawsuit was essentially about harassment, but they were potentially looking to add, now that Danny has been convicted, the sexual abuse claims into the lawsuit. They were looking to add civil racketeering claims against, well, the defendants in the lawsuit, and they were looking to add another plaintiff, one of Danny Masterson's victims, Trish Vesey. All of that is also pending, and my personal opinion for right now is that that may also be a contributing factor to the judge's decision to be like, nope, we're taking a timeout for now. Now, even without adding any additional plaintiffs or complaints to the lawsuit, this suit's going to be on ice for like a year. I believe there's a very good likelihood that if they were to actually add the additional complaints to this lawsuit, instead of just making it a separate lawsuit, if they were to add the additional complaints and add another plaintiff, my understanding is that restarts the clock. Scientology can now make new anti-slap motions against the new complaints and all this kind of stuff. That could potentially extend the lawsuit for many more additional years, but it may make more sense and be less messy and take less time for new complaints and new plaintiffs to be the subject of a new lawsuit. But what do I know, guys? I grew up in a cult. All right, let's look at some other items in this tentative ruling. Plaintiffs contend the court should reconsider its May 29 ruling, whereby it stayed the entire action pending defendants' appeal of the anti-slap motions because they were not afforded the opportunity to brief the issue on the scope of the stay. Defendants argue plaintiffs did have an opportunity to brief the issue and strategically chose not to. Defendants further argue that the plaintiff's request is procedurally flawed, as there are no new facts or evidence supporting reconsideration. As an initial matter, the court notes that plaintiffs did not provide notice of the May 29th ruling as they were ordered to do. Notice is the triggering event for the deadline to file a motion for reconsideration. Now, I got to admit, when I first read that, I did not understand what it was saying. I thought, well, certainly it's the court or the judge who should be notifying parties of a ruling. Why would the plaintiffs need to notify the defendants of a ruling? So anyway, I looked it up, and here's what I found that seemed to make sense. It says formal notification. The party who receives the ruling, often the winning party, is responsible for notifying the other party or parties. This is usually done by serving them with a copy of the written ruling. Further, it says starting the appeal process. The notice of a ruling also triggers the timeline for filing an appeal. Once notice is provided, the clock starts ticking on the deadline to file an appeal if the party disagrees with the ruling. Again, I'm going to check with my lawyer friend, Zach, but it seems that if the plaintiffs were going to appeal, the official first step of the process is to formally serve the defendants with a written copy of the judge's order that they would be appealing, even though the defendants were there in the courtroom when the judge's decision was made. Again, not sure if I'm interpreting it correctly, but that is the only way this paragraph of the tentative ruling makes sense to me. So that's what I'm going with for now. Okay, it continues on with, as to the merits of the plaintiff's motion for reconsideration, the court is not persuaded that relief is warranted. First, plaintiff's contention that they were not afforded sufficient opportunity to brief the issue of the scope of the stay is not well taken. Defendants argued that the stay encompassed all of plaintiff's claims in their opposition to the motion for leave to file a second amended complaint. Plaintiff's reply did not address the scope of the stay. Furthermore, at the hearing on their motion, plaintiffs requested further briefing, which the court addressed. Plaintiffs had 69 days to further brief the scope of the stay issue before the hearing, since it was continued from March 20th to May 29th. Indeed, there was no surprise that defendants would likely file such an appeal. As such, plaintiffs have not demonstrated new facts or circumstances warranting relief. Accordingly, the court denies plaintiff's motion for reconsideration. Well, that is a bummer. It does seem to me that if this request had been made earlier and in a different way, that perhaps it would have succeeded. And it just really is kind of a bummer. I guess this is just one of those examples where sometimes in a court of law, it is not about what is right. It is about whether it is done right. So anyway, that's a bummer. That's a bummer. It looks like we won't be hearing anything about this lawsuit for close to a year. So guys, what about the other lawsuits? I said there's 5 lawsuits. So of course, there's this lawsuit, which is the Bixler lawsuit. There's Leah Remini's lawsuit against Scientology and David Miscavige. That is also currently on appeal, again, following rulings in an anti-slap motion. Also, that gets a little more complicated. Leah Remini's entire legal team had to step down Another firm has stepped in to represent Leah during the appeals process. It's not entirely clear whether that team is only there for the appeal process, or whether they're planning on continuing to represent Leah in that litigation. So there's big question marks surrounding that lawsuit. There is another lawsuit brought by Jane Doe 1 against David Miscavige, Church of Scientology, some other Scientology entities, and a Sea Org member named Gavin Potter, who Jane Doe 1 was married to. This is essentially a child SA and trafficking lawsuit. That is moving forward full steam ahead. There's a lawsuit brought by a woman named Valerie Haney, who used to work directly for David Miscavige and Shelley Miscavige. She escaped from Scientology's international management base in the trunk of the car of a non-Scientologist who was on the base shooting a film for Scientology. That's one of the lawsuits where Scientology succeeded in getting the entire thing diverted into internal religious arbitration. And so it looks like Scientology has, for now, killed that lawsuit. There is another trafficking lawsuit against David Miscavige and Scientology and other entities by 3 former Sea Org members, Gawain Baxter, Laura Baxter, and Valeska Paris. Again, in that lawsuit, Scientology has succeeded in getting it diverted into internal religious arbitration. And so for all intents and purposes, for now, has killed that lawsuit. But until it's done, dead, and buried, I consider it to be an active lawsuit. So out of the 5 active lawsuits, you've got 2 that have been derailed into internal arbitration. You've got 2 that are on appeal for anti-SLAPP reasons. Those are going to be on ice for about a year, both of them. And so the one that is like actively moving forward ahead is the one against Gavin Potter, David Miscavige, Bridge Publications, Church of Scientology International, etc. That's the landscape of Scientology litigation right now. As there are updates in any of these lawsuits, I will, of course, do my best to bring them to you. Thank you, everyone, for watching. Thank you, as always, to everyone who watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.